Hi, and welcome to this installment number 10 of the Elder Law 101 series that I have been doing and that I have adapted or updated for 2025. If you haven't seen any of these before, my name is Arthur Bergeron. I'm an attorney. I do nothing but elder law, and I've done nothing but elder law for about 15 years, working as of counsel at a firm called Myrick. Used to be called Myrick O'Connell. We have around 80 lawyers, main offices in Worcester, Westboro, and Boston. We're the biggest firm in Massachusetts outside of the city of Boston. The point of this series is to help my clients and to help you, hopefully, to look at issues that a person would face typically if they're in their 60s or after. That's what I define as elder law that has to do with folks who are getting to an age where they may be retiring or it's after retirement and they're getting older and they're trying to anticipate issues, or the issues are already upon them, or they're dying or dead, and there's estate administration issues, and then dealing with what happens with what's left after you die. So the series, of which this is episode 10, started off with just dealing with incapacity and estate planning issues before you're 60. When you're that young, you're really just worried about if there's an accident of some kind, you get hurt, how do you deal with that? And if there's an emergency, if somebody does get hit by a truck or whatever, how do you deal with those issues? Then considering things in your 60s was episode 2. When you're kind of thinking about, well, do you want to be taking Social Security? Do you want to go on Medicare? How do your tax deferreds work? All those issues. Dealing with your 70s, at which point you're getting older, you're probably not working, and you're now starting to get a little bit worried about frailty, and you're thinking more about death, actually, because that's the age. Then I do one specifically regarding income tax basics for seniors, because there are unique issues that seniors face in terms of tax deferreds, in terms of gifting, in terms of a whole, balancing capital gains and estate tax issues. That's what that's all about. Then I talk about life in your 80s, at which point you may very well be trying to face these kinds of frailty issues, dealing with nursing home issues, dealing with qualifying for Mass Health. Then I have a specific episode in episode 6 talking about why it is that you can always qualify for Mass Health, contrary to popular belief. Episode 7 is dealing with the last year of your life, which actually you may be in right now. You just may not know it. But we talk about those issues regarding thinking about frailty, the various paths to death, because we all die, right? And then how you face all of those issues. In episode 8, we talk about dealing with the things you left behind after you're dead. In 9, we talk about trust, because one of the first questions I always get asked by every new potential client is, everyone's told me I have to have a trust. How does all of that work? Well, this talks about how it works. Episode 10 is the episode we're going to do today, dealing with the kids and the grandkids after you have died, figuring out those issues. Episode 11, we're going to talk about your Medicare package, obviously a big issue for all seniors. And finally, in episode 12, it's 'tis the season. When I did these seminars originally, I had 20 or 12 episodes. The last episode was around December. We talked about giving, not only the giving during that time, but also looking at pulling out extra tax deferred money, a set of issues that you need to face uniquely in December. So here we are. Today's episode is about, as I said, dealing with your grandchildren and kids given those issues that they may be facing after you die, and figuring out what you have to do as an estate planning matter, or may want to do to deal with those issues after you die. So I always talk about my friends Frank and Mary and their kids, Peter, Paul, and Mary Jr. And I'm going to talk about them today. I'm assuming that I'm talking now about not what happened when Frank died, because I'm assuming that probably what happened was that everything at that point went to Mary. But what happens if Mary now dies? I'm assuming here that Mary has a house that's worth not a huge amount, $400,000. I'm assuming she has a cottage, though, that they bought ages and ages ago for like nothing. This little crummy place on the Cape, or on Nantucket, or on Martha's Vineyard, that, in 1980 they paid $50,000 for, and it's now worth $1.4 million, right? By the way, this is no lie. There are a lot of these cases. I'm assuming that Mary has an IRA, probably some money that she got rolled over from her husband when he died, but she's got an IRA worth about $300,000, savings worth about $200,000, total assets of about $2.3 million. Now, we're not going to accent the fact that that amount is so high that there are some estate tax implications, but we are going to talk about it. Right? So, Mary dies the day after Frank dies, and she's now got all the assets. What happens if she hasn't done anything for estate tax or for estate planning purposes, and she doesn't even have a will? Well, what happens is none of the assets go to the state. There is this kind of theory that, oh my God, if I don't have a will, all the assets go to the state. It may be that there'll need to be a probate of this. It probably will need to be a probate unless she's named death beneficiaries on all of these assets, right? Or unless she owns them jointly with someone. But the point is, if there are assets that need to go through the probate process because she dies and leaves them just in her name, and there's no will, then in this situation, what she wanted to happen, which was that all the kids would get equal shares, would be exactly what would happen. Assets would simply be divided equally. And if any of the children has predeceased her, then that child's assets are going to go to that child's surviving children, right? And if any child is under age 18, then money is going to get held by a guardian that gets appointed by the court to hold the money until the child is age 18, at which point the assets will be distributed. If there are no children, the assets are going to go to Mary's siblings. And if any one of her siblings has died, then that share is going to go to that sibling's children. So there is a system that will cause the assets to be distributed. And if that's the system that Mary wants, or in your case, if that's the system that you want, you don't need a will. You don't need a will. But it may be that that's not exactly the system that you want, because there may be problems, right? For example, suppose, you love Peter and he's your oldest son and he's just wonderful, but that wife, you're just not crazy about her, right? And she's, there's been conflicts and she's always been grousing about her share and blah, blah, blah. So what do you do with the wife, the daughter-in-law that you're really not crazy, and you think there's a reasonable possibility Peter isn't crazy about her either, and that things may be headed for divorce at some point down the line or whatever. Well, if this is actually your situation, then I would strongly recommend that you also bring a divorce lawyer into the conversation in order to be comfortable about your decisions. In general, I can tell you, right, one of the issues in Massachusetts, if Peter is in Massachusetts, because this would be a matter of Massachusetts divorce law, and this varies by state, is that if there is a divorce, assets don't necessarily get divided equally between the two parties, right? But equitably. So the judge takes, in dividing up assets between two spouses, gets to take into account whether one spouse at the end of the day is simply going to be better off because of other things, including, like in this case, the fact that he may be inheriting a lot of money, right? Or has inherited a lot of money. How do you deal with that, right? Well, one way would be to cut Peter out of the will completely. That's a pretty drastic, and then just trust that your other children are going to kind of take care of Peter. Another possibility would be to have asset, and this is what people kind of come in this situation assuming they need to do, to take Peter's share and put it into some kind of a trust for his benefit. Will that provide that kind of protection for him if there is trouble down the road? Not necessarily, right? Because the courts, in this, once again, this is a matter of current Massachusetts divorce or divorce law. So we really want to include a divorce attorney in this conversation. But the current law, it is my understanding, right, is that if the money is going to go in trust for the benefit of that child, right, then the real, even if that trustee has complete discretion over how much to distribute to that child, right? If that child is like a sibling, and that trustee it has complete discretion, it may very well be that the court will say, in that case, as a practical matter, it's really Peter's asset, and so I'm going to treat it as such in figuring out the division of these assets. One possibility in that case would be to name a professional trustee, not one of the siblings. Another possibility would be to limit the distributions or the discretion of the trustee, so that you say, for example, the trustee only has the discretion to distribute trust income every year, right? Another possibility would be to have the assets go directly to the grandchildren or as beneficiaries, and name a third party. Probably you don't want to name Peter as the trustee, but name a third party as the trustee. So you have some options, but the point is, this is the kind of issue that you should be trying to resolve by talking to your attorney about it. How about if there's a disability? Say Paul has a disability of some kind. So how do you deal with that? Well, the question is the questions you want to ask yourself are, what is the disability? What's the nature of the disability? And what is the nature of the government programs that you're trying to protect from? Because you don't want, as a result of Paul having a disability, you don't want his inheritance to end up making him ineligible for one of these programs. And so it may very well be that that ineligibility costs him more than he benefits from getting the inheritance. So you first want to look at what the programs are. If, for example, Paul were on SSDI, Social Security Disability Income, because it had been determined that he has a disability that will keep him, he's totally and permanently disabled. That means he cannot earn money himself. Well, in that case, leaving money to him will have no effect on any of this. As long as he's not earning money, right? As long as he's just inheriting it, that does not affect his Social Security disability checks. If he were actually taking another job and earning money, then his SSDI income would shrink by the value in relationship to the value of the money he's earning. That's not the case though with an inheritance. On the other hand, if he is getting mass health of some kind, he may very well be affected by an inheritance, which may cause him to be over the asset limit. And that's especially going to be true if he has serious problems and may need nursing home care. But the point is, in all cases, you can avoid this problem by creating a trust for Paul's benefit and specify and naming a third-party trustee. You can give that trustee infinite discretion regarding giving money to Paul. But because it's in a so-called third-party funded trust, that is a trust that was funded not by him with his assets trying to hide them, but rather by you as his parents, those assets will not be countable or lienable or affect his mass health qualification. Kind of similarly, if he's on SSDI, if he's on SSI, Supplemental Security Income, as opposed to SSDI, Social Security Disability Income. So he's on SSI simply because he's poor, not because he has a disability. Well, that program is affected by his assets and his income because the theory behind supplemental Social Security is that it's meant to boost his income to a level that would allow him to live. So if the trust, if money is going into trust for his benefit, but the trust specifies that he's getting the income, then it may very well be that it will keep him from getting the SSI income because it will reduce or eliminate the subsidy necessary to get him to the level that SSDI says he should be getting because he is so poor. So the answer in that case may very well be to set up a trust, but also to make that trust specify that the trustee is not actually handing Paul any money, but rather buying things for him, buying goods and services for him that will not affect his income and therefore not affect his eligibility to have this supplement come in, right? So it really depends on the nature of his disability and the nature of the programs. As I mentioned, though, one way to deal with a lot of these issues is through something called the Supplemental Needs Trust. Once again, you want to talk to your attorney about that. It may be regarding that trust that there needs to be some control on the trustee's discretion to give him income and things. You may also want to figure out how that might affect his housing, if he's getting some kind of a housing benefit. And in the case of these trusts, you also need to figure out what happens at the end of the day. Supposing that there's enough money in there that Paul doesn't outlive it and there's still money after he dies, where does the money go then? Finally, take Mary. Say that Mary doesn't have a disability and she doesn't have a divorce problem because she's single, but she's kind of a mess and she's behind with her creditors, and you think will continue to be because she's not good with money. And so you're concerned about inadvertently leaving your money really to the IRS or to her creditors, right? Well, in that case, once again, the solution may be to set up a trust for her benefit, name one of your kids as the trustees. In this case, there don't need to be any constraints on their ability to distribute to Mary, but you may want to create some constraints so that otherwise Mary's not constantly fighting with the trustee. That's especially important if you're naming one of the siblings as the trustee, right? So, trust issues. Is the sibling appropriate, or do you want to name not necessarily a professional trustee? Professional trustees like banks and lawyers and professional are very expensive. I always tell people, the best trustee to have, you put him in as a trustee because you trust him, right? The trustee can always hire professional help, banking, investments, lawyers, accountants. The main thing is, do you trust that person? Once again, there's that issue of what our final, can there be a final distribution to Mary during her lifetime if she kind of straightens out, which sometimes happens, right? Where does the final money go after Mary dies? Finally, though, there's dealing with the grandchildren. In general, I tell my clients, leave your money to your kids and try to not leave a whole lot of money to the grandchildren, because if you're leaving it basically because you want to pay for their college, unless they're older, right? Because if you're leaving it to pay for their college education, it may very well be that you end up, as I say to people, you maybe think you're leaving it for your child who's going to go to Harvard, but you're really leaving it to Harvard because the amount that you leave in trust may very well have an effect on how much Harvard's going to give him when he or she fills out that FAFSA application, right? You may want to put the money in a so-called 529 plan for the child's benefit, but once again, the question is, how is that going to affect any college benefits that he might have? And incidentally, I'm doing a separate program. I'm doing a series of shorts between 5 and 15 minutes long called Myrick Pearls of Wisdom, talking about more in depth about specific issues you might be facing, and this is one of them. And it's especially important now because the rules regarding what you can use 529 plans for were drastically changed as a result of the so-called Big Beautiful Bill that got passed proposed by Trump and got passed by both houses of Congress this year. So there were a lot more things that money can be used for, and there were some changes regarding what happens to that money if it isn't used for those things, in terms of whether that money or how that money can be rolled into an IRA or a 401 or an IRA for the benefit of that child, right? And once again, one of the questions that you want to be facing on the 529s, or as well as on any kind of trust for the benefit of these children, is who's going to be the trustee? Do you want an older sibling to be the trustee? Do you want a third party to be the trustee? And since this could be happening far out into the future, make sure that there are successor trustees. Now, assuming that Mary's trying to figure out all of the issues that I just talked about, the question is, what is the best vehicle? Well, one vehicle would certainly be to have a will in which Mary either has all of these rules regarding, dealing with trust for the benefit of the kids or the grandchildren in the will, right? Or to have a standalone revocable and amendable trust, a trust that Mary can change at any time, where she names herself as the initial trustee. She may or may not put assets into that trust right now, right? And just leave them as trust, so that she's the trustee for her own benefit while she's alive. But then she'd specify that following her death, somebody else would step in as the trustee for her benefit, right? Or there's a possibility that she could, own these assets jointly with, safe with one of her kids, or name her kids right on the accounts that she has individually, so-called pay on death or POD, or transfer on death, TOD accounts, right? The issue with any of those kind of, what I'll call the poor man's wills, or it's called poor man's wills, the POD account or the joint ownership account, is what happens if there's a problem with the other person that you've named. If you were assuming that Peter the oldest son, the golden boy, is all going to be fine, and he's going to just distribute all the assets appropriately. That's great. If it turns out that Peter isn't doing so hot, or that he's got other issues at the time that you die, though. For example, he's got creditor problems, maybe he's got IRS problems, maybe he has divorce problems. In those cases, if he becomes the owner of those funds, either because he was named as on the POD or because he's the surviving joint owner, his creditors and his wife, as far as they are all concerned, they're his assets. And so they can be grabbed by the creditors or by the wife, right? It may be that you do want to do a will, right? And it may be that you want to have all those rules in the will, right? The only problem with handling things through the will, though, right, is that before any asset, the point of a will is not to avoid probate. I often have people say, oh, I have a will, so I'm not going to go through probate. No. The point of a will is to specify where the assets get distributed. Because if there's no will, you face the rules of intestacy, right? So, but the second point of probate, first of all, is to make sure the assets go to the right people. The second reason, though, is to make sure that creditors get paid. And creditors would have 1 year from the date of your death to file a claim against the probate estates. So if the assets are passing through the will, then first they have to sit, because creditors will have 1 year from the day of your death to file claims against the probate estate. At the end of that year, they can be divided up. In the meantime, there's quite a bit of legal work that needs to get done to get the will approved, to deal with other issues, to finally close out the estate. And that's the place where there are arguments. There can be arguments. So that if Peter, Paul, and Mary Jr. are not really getting along well, you probably don't want to have things passed through the will, right? Probably what you want to have in that case, or Mary would want to have, would be a revocable and amendable trust. Revocable in that whatever she puts into it, she can always take back out of it. Amendable in that she can change it at any time while she's alive. But at the moment of her death, somebody else is going to step in as the new trustee and be able to distribute all assets. There's a lot less likelihood of arguments. All creditors will be wiped out and the assets can be distributed immediately. Now, I'm just going to mention the revocable and amendable trust doesn't protect any of these assets as far as Mass Health is concerned. If she's trying to protect herself because she may need nursing home care, she may need an irrevocable trust or to do other things. If you're concerned about that, watch the episode all about trusts, or watch the episode that deals with why you can always qualify for Mass Health. Finally, excuse me, I want to talk a little bit about Mary's cottage. One of the goals, oftentimes, my clients will come in, they'll say, when they die, they just want their assets just divided up among the kids, except the cottage. Because the cottage has often got these really fond memories, and the kids have used it, and the grandchildren have used it, and they really want to keep that. So they want to keep the good times going regarding the cottage. What they also need to be thinking about, though, is if they want to keep the cottage, they want to make sure that they're keeping all these bad things from happening, of which I have seen a lot of different varieties because I do a lot of work on the two islands. My Thursdays have been, for the last 12 years, have been Island Day. I alternate Martha's Vineyard and Nantucket, where nobody ever wants to sell the house. Everybody wants to keep it for the benefit typically of the children or the grandchildren. So there are a couple of ways you can do this in terms of dealing with the cottage. You can, if you're assuming that you would like to not have the cottage sold, you'd like to keep it in the family. Option one, figure it out. Figure it out how you want that to be handled, either you and your kids, before you die. There are a set of issues that you need to talk about. There are not an infinite number of issues, but I've done a memo for clients who have got cottages. I always call it cottage law, in which I list the issues. And there are about 60 of them. Some big, some really small. Not an infinite number. If you get to the bottom of the list and you've answered all the questions, you've probably covered all the issues. But it's a lot, right? Like, for example, if you've got multiple kids and you've got a place on a vineyard, on the Cape or the Vineyard in Nantucket, and they're all going to be using the cottage, that's great. Who gets what week? When does a week start? Does it start on Saturday? Does it start on Sunday? Does it start does the week start at 4 in the afternoon, but the other person's got to be out by 9? Because that's kind of commercially how the deals usually look. Who figures out the budget? Like who's going to pay the taxes? Who's going to pay the insurance? Who's going to make sure if the roof falls off that it's going to get replaced? For many of these places, who's going to deal with the septic system? This big, it's like this kind of the ticking time bomb, and inevitably the septic system. Once you figured out the budget, who's collecting the money to manage that budget, to make sure that all the bills get paid? What happens if somebody doesn't pay? What happens if you've got, the folks, Peter or Paul is living in California and he's got kids and he's only very occasionally coming, and he says, I really can't, and his kids are growing up, I really can't afford this. Well, what happens? What happens, right? Which also directly relates to how does it end, right? What happens in the short run if Paul's not paying? Does that mean he doesn't get any more weeks in the cottage? Does that mean, and what about if the cottage gets sold, right? Does that mean he doesn't get a share of the proceeds of the cottage? And what if it's sold, not 10 years from now, but like the week after he says he's not paying anymore? Does that mean he's just out, right? So there's this whole set of issues that you need to kind of think out, right? Option number 2 is what I always call the nuclear option, right? Don't think about any of that stuff. Make it very simple for your kids. When you die, the cottage is going to get held for 6 months. And at that point, if everybody hasn't agreed on what they want to do with the cottage, they're going to sell it, right? If you want, you can also put in a provision because you'd like to keep the cottage in the family, but you don't like it so much that you want it to cause fights, is you can say, if one of them wants to buy the cottage, right, they can. But then the question, of course, is, what's the price? Because if you're the buyer, this is the market. If you're the buyer, the price is always too high. If you're the seller, the price is always too low. So the question is, how do you figure it out? What I always tell people is, you can't. What's an appraisal? Appraisal is a kind of a useless document because it's just an estimate, really, of what's going to happen in the market, right? The legal kind of definition of fair market value. It's what a willing buyer will buy for, and what a willing seller will sell for. Whatever that number is, and that can be a lot of different things. That's the fair market value. Easiest thing to use is the assessed value. Say at the moment of your death, what is the assessed value at the assessor's office in that town, right? Now, in a market that's climbing, the assessed value typically chases that number up, so it's typically lower. In a market that's falling, the assessed value chases that number down, right? So it's not going to be an exact number, but it's a real number. Everybody can go to that. If you want to make an adjustment because you really want to keep the cottage in the family, you might say that if someone's buying the cottage, they get to buy it at 90% of assessed value or 80% of assessed value. Or if they buy it, they don't have to come up with all the cash. If you're buying the cottage that was worth nothing in Nantucket's now worth $2 million, you don't force the buying child to have to come up with 80% of $2 million or 2/3, because you say a third of it was that person's share. There's 3 kids. 66% of $2 million, by getting a bank loan, right? They've got their own lives. But so you may want to say, well, they get to pay that, over time, or they get to pay it like in 5 years. So you want to figure it out. And then you may want to say, if no one has bought at that assessed value or at that magic number, and then it goes on the market, you may want to give the kids, any of the kids, a right of first refusal. So if a third party comes in saying, yes, I'll buy it for $1.5 million, you give the child not a long time, 48 hours, to match that offer, right? And as I mentioned, if you're actually transferring it to the children, you may want to consider, an option through which the child who is buying gets financing basically from the other 2 kids, but so you could talk about it. But the point about this is you'd want to talk to your lawyer about it. Finally, avoiding the estate tax. Very briefly, the estate tax threshold the federal estate tax is irrelevant to you. The estate tax threshold in Massachusetts is now $2 million. As I noted at the beginning of this presentation, we're assuming that the total value of this estate is $2.4 million, which means you're over, which means there would be an estate tax in this case. It wouldn't be huge. First of all, it wouldn't be huge, though. Once you go over $2 million, the only amount that's taxed is the amount that's over the $2 million. So in this case, it would be about $400,000. And the rate of tax, there's a graduated scale, but for dollars, those first dollars over $2 million, the tax rate, if I recall correctly, is 7.2%. And then once it gets to $2,040,000, I think it goes to like 8%. So it's not really high. So the tax on that extra $400,000 would be 8%, $30,000, $40,000. It wouldn't be like a gigantic number, right? But as I mentioned in a different Myrick Pearl of Wisdom, there is no gift tax. And as a result of this change in the estate tax law, if you make a gift, it doesn't, the value of that gift doesn't get clawed back for figuring out these numbers. So one of the things that Mary could do was simply give her away out of the estate tax by making sure that before she dies, she gives away $400,001, right? Or because if the total, and remember, the cottage isn't worth everything, it's worth a big chunk of the money. But she could give away some of her cash, thereby keeping the house and making sure that when she dies, the so-called tax basis of that house will still jump to the date of death value while avoiding the estate tax. So, remember, as I always say at the end of these presentations, this may all be irrelevant to you. The question is, what's keeping you up at night, right? When you get to our age, fame and fortune has passed us by. The question is, how can you get a good night's sleep? So if these issues aren't bothering you, then forget them. If any of them are bothering you, go talk to your lawyer, right? And if you want to talk to me, it's easy to reach me, right? You can check. Frank and Mary actually have their own YouTube channel, Elder Law Frank and Mary. You can check there. Or you can call me anytime. I never charge for advice, which I love to give, as you can tell from this presentation. Thank you very much, and I look forward to talking to you on the next presentation. Thank you.